Started. Might as well. Okay, thank you. We're going to reconvene for the final session, which is looking forward.
Thanks. I'm Abner Green, and I think the bios of all the panelists are in your program, so I'm not going to say all the wonderful things about them. Each of the panelists is going to speak for 12 minutes, and then I'm going to offer a few thoughts, and then we'll have Q&A from the floor to close this great 3 days of discussion. So we'll start with Bill Eskridge.
Thank you. Well, I think our panel is called Looking Forward. Well, looking backward just a little bit, I would like to appreciate the organizers, and particularly Doug Nashame for setting up the PowerPoint for today's session, which I think would not have occurred but for Doug's assistance. In terms of looking forward, I'm looking forward to marriage equality in all 50 states and the District of Columbia. So beyond looking forward and looking forward specifically on the topics of today's conference, what I want to focus on, like Sally Gordon, is a bit of history. And the suggestion is how the Civil Rights Revolution helps us understand recent clashes between religious liberty and LGBT equality. It seems to me, based upon yesterday's program and a little bit today, that the premise of much of the conference is direct. It was called existential, zero-sum, clash between LGBT rights and the rights of religious persons and religious institutions. And I do think there's a parallel to this clash, and I do want to resist the stark existential clash that has been posited. The civil rights movement and fundamentalist religion, particularly in the South, were deeply at odds in the 20th and the 19th centuries. And specifically, Southern Protestant churches and LDS, the Mormons, read scripture to support slavery, then apartheid, and then anti-miscegenation regimes. I'm using PowerPoint because I don't want to read the Bible verses. The Bible verses are anodyne. The interpretations placed upon them are repulsive. I will give you just simply 3 examples, and I've published an article that recounts in great detail the effect of these Bible verses on religious faith and practice in the South in the 19th and 20th centuries. Noah's curse on the screen was used in the 19th century as a biblical justification for slavery, not as an apology for slavery, but as a God's blessing on slavery. Nimrod, who was the grandson of Ham, who was implicitly cursed by Noah, is the story that was used, and these are not the only stories, but these are central ones, as the biblical justification for and indeed requirement of apartheid. And then the opposition to different race marriage or miscegenation was justified and indeed required by these earlier sources and many others, including St. Paul, who was replete with justifications for these kinds of things, by Isaac's blessing upon his son Jacob, saying that he shall not take as his wife the daughters of Canaan, who was the son of Ham, of course. So in the period before slavery, most of the major Protestant denominations believed that slavery was required by the Word of God as they interpreted the Bible. This was not true of the Roman Catholics and was not true of Reformed Jews. Before Brown versus Board of Education, a number of denominations, including the Baptists prominently, believed that segregation was supported by the word of the Lord. The Presbyterians originally believed this, the Methodists did, but by 1954 they'd fallen away. And then before Loving versus Virginia, a few religions, not as many, believed that miscegenation laws were also required by God's word. Now, the punchline of all of this does set up some very distinct and perhaps useful parallels between the support for discrimination against African Americans in the 20th century and discrimination against LGBT people in the 21st century. As you know, and I'm not going to recount the passages, though they're there if you want them, these are leading passages in point number 1 that are used by some religions to demonize same-sex relationships and even gay and lesbian marriages. And what I would suggest, as you look at the passages I've given you for Noah, et cetera, one of the things that you immediately notice, I hope, is that the racist readings are exaggerated and ahistorical readings of isolated Bible passages to denigrate a minority and probably to justify pre-existing prejudices that one might have. And I would suggest that the biblical case against same-sex relations is based upon a similarly exaggerated and ahistorical reading of isolated Bible passages, which I've given for you. And notice that all of these ignore the teachings of Jesus Christ, after whom the Christian religion, of course, is named. Second parallel, and that is that there is a similar progression from using originally Bible passages to support dehumanization, slavery, also later on sodomy, criminalization, death, the original biblical punishment for sodomy. Then once slavery was ended, to support apartheid. Then once apartheid was being dismantled, still to support marriage exclusion, all with biblical support. So there was a sedimentary quality of these justifications. And then there was a similar pushback, different times, of course, by progressive social movements, the civil rights and then the LGBT rights movement, to reclaim the minority's humanity, then to demand integration, and finally to insist on marriage rights, with religion-based counter-movements shifting to accommodation demands as the social movement picked up steam. And we should not forget that the civil rights movement did generate, as it was winning, a number of accommodations, including the Title VII religious accommodations, because remember, when these Southern religions were racially segregated, a religious accommodation for them, or at least for some of their institutions, was a race accommodation as well. It meant that they were legitimated in their racist hiring, since LDS, Southern Baptists, et cetera, could, in some cases, hire only from their own social group. Bob Jones, which has been adverted to, is another example of this playing out in the court cases. Now, here's a second point I want to make from these parallels, and that is that not only did the civil rights movement nonetheless gain important victories in both the legal and the social arena, and the LGBT rights movement similarly, but in the course of the changing law and social norms, religion itself changed in the period I'm talking about. I grew up in the South. I was Presbyterian, surrounded by Southern Baptists, and it was saturated with racist readings of the Bible, which were accepted and were used as justifications. So the success of the civil rights movement, I can document, and I knew it from my own life, did stimulate changes in Southern Protestant and LDS religions. And there are three kinds of changes, and different religions went through different phases. One is, initially anyway, there was a de-emphasis on the previous focus on race-based beliefs. In other words, you can fail to abandon your beliefs, but de-emphasize them, not make them central to your religion. And even when religions continue to discriminate internally, they often endorsed public non-discrimination, as the LDS did in the 1960s and as the Methodists did in the 1940s. A next stage is that there sometimes and typically emerged open tolerance, with either disregard or closeting of previous doctrine and some integration. We saw that with the Methodists and Presbyterians in the 1950s. And then finally, most of these religions actually by today have utterly rejected previous doctrine. The Presbyterians and the Methodists by the 60s, the LDS in a revelation from the Lord in 1978, the Southern Baptists issued public apology in the 1990s, and Bob Jones issued a public apology in 2000 for the record. The American religion is also, though in a different time period, as we speak, changing in response to the LGBT rights movement and social changes. In my article, I document this in small part by looking at amicus briefs in Romer in 1996, in Lawrence in 2003, and then marriage cases that have already been or are going to be filed in the new millennium. And the same kind of changes are happening, different paces, different religions. Number one, some religions are starting to de-emphasize previous focus on gay-related beliefs, not race-related, but gay-related beliefs, and endorsing public non-discrimination even when discriminating internally. We've seen that with the Catholics. We're seeing that with many Protestants. That is a change. Moreover, open tolerance sometimes with disregard for previous doctrine and some integration. The Methodists and Presbyterians are moving in this direction. Some of the rhetoric from Pope Francis I gestures in this direction as well, perhaps. And then, one by one, different religions are now rejecting previous anti-gay and lesbian doctrine. And you see the list there, and there are obviously more to come. Now, what lessons do I draw from the parallel experiences of religion interacting with these social movements and with society, obviously? Lesson number one is that society, the church, and state are mutually constitutive. Cultural norms will be translated into religious doctrine. They will reflect them. As cultural norms change, religious doctrine will change as well, not side by side. Religion feeds into cultural norms, but so do state rules and normative discussion. This makes me skeptical that there is an existential clash between LGBT rights and religion, especially as the latter changes in response to the former. Lesson number two is what I call equality practice, keeping the stakes low. Exactly as Andy and John and others have suggested, I think social change and legal reform do not stick in our culture until at least some major religions have abandoned their opposition. And so I think an important forum, not just an important opposition, an important forum for LGBT rights is within religion. And that ought to caution us against excluding or writing off religion from LGBT rights discourse. And indeed, a harbinger for victories in Romer and Lawrence was the religion briefs were overwhelmingly in favor of LGBT rights, with the LDS, the Baptists, and the Catholics not filing anything in opposition to us, and a lot of religions filing things for us. I documented this point even on same-sex marriage in the early 1990s, when my marriage clients in D.C. collected about 100 letters from religious organizations and leaders supporting marriage equality in the 1990s. And then finally, I would urge, do not overreact to religious accommodation provisions. In my view, accommodation provisions typically lower the stakes of marriage equality and other advances. I resist the conclusion that they necessarily encourage counter-movement opposition to LGBT rights. Under the conditions we are now seeing, rising public support for marriage equality and other rights, I'm very doubtful. And instead, accommodations are more likely to encourage dialogue within at least some traditionalist religions. And I invoke the Boy Scouts case, in concluding, we lost the case, but we won the Boy Scouts dialectic war, and might, as a social movement, have done better losing the case than winning the case. I offer that as an ironic and perhaps objectionable point that can be pursued in questions and answers. Thank you. I should not touch anything for fear of destroying.
What, just leave it? Okay. Although there may be someone who knows how to get the screen back up.
She's going to give the same presentation, but with the opposite bottom line.
They could do it for us if
No,
there's
yeah,
someone.
no, I've got a presentation.
Oh, you have a
Yeah,
presentation,
I'm
so
gonna
we'll
give
leave.
Bill's again, but with a different.
She's
font.
gonna. All right, so panelists can resume the dais. Bill and Priscilla.
Good morning. I first want to express my gratitude for being able to participate in this really wonderful conference. I've learned a great deal as someone who doesn't study or write about religious accommodations. It's been a really rich experience. I want to thank Doug in particular and Brad as well, the Williams Institute, the ACLU, and others for bringing us all together. I am very cognizant of the fact that this is the last panel of the day. And so I want to invoke a saying that folks at a church I went to when I was a kid used to say. They said, "Blessed are the brief, for they shall be invited back." So, I'm going to try to stick to this brevity point, even unclear on the invited back piece, but I'll try to stick to the brevity piece. To start, I want to note a recent case of Renee Gibbs, a 24-year-old African-American woman in the state of Mississippi who was charged with depraved heart murder. For those of you who've taken criminal law a long, long time ago, depraved heart murder requires a reckless disregard for human life. She was charged with depraved heart murder at the age of 16 after she gave birth to a stillborn child prematurely after 36 weeks of pregnancy. The child was born with an umbilical cord wrapped around its neck, which was initially thought to be the cause of death. After some blood tests, the cause of death was later revised to cocaine toxicity after trace elements of the drug of cocaine byproduct were found in the baby's system. Just this week, the Mississippi Supreme Court dismissed the charges against Gibbs, citing Buckhalter versus State, a 2012 another Supreme Court case that cast doubt on the propriety of using a homicide statutes to prosecute pregnant women for the harm done to an unborn fetus. I raised the case of Renee Gibbs for several reasons, which I'll discuss more fully in my time. The first is to shift the conversation from religious accommodation in the context of reproductive rights to the emerging pattern of religious objection to abortion manifesting themselves through criminal prosecutions that advance this notion of fetal personhood. In some ways, we can see this as the rise of fetal personhood and the decline of women as distinct persons in and of themselves when they are pregnant. The second is to shift the conversation from contraception and abortion to note the ways in which fetal personhood prosecutions disproportionately criminalize poor women of color who choose to become parents and therefore reinforce their subordinate status in society. Lastly, I tell the story of Renee Gibbs to highlight the ways in which the punishment of poor women of color for negative pregnancy outcomes at once blames them for the social problems that may underlie those outcomes and relieves the state of its obligation to address problems such as poverty, lack of access to health care, and race discrimination. Now, I know this panel is titled Looking Forward, and I guess this isn't much that's good to look forward to. So to start, this notion of the fetal personhood movement. 38 states have enacted fetal homicide statutes. Initially, these laws were passed to punish third parties who caused the death of a fetus. Increasingly, however, states, particularly those in the South, have used such statutes to prosecute pregnant women for negative pregnancy outcomes, such as stillbirth, or for conduct that could potentially cause negative pregnancy outcomes, such as drug or alcohol use. Several states, including Mississippi and Alabama, have placed fetal personhood initiatives on the ballot. These initiatives have redefined person to include, and I quote, every human being from the moment of fertilization, cloning, or the functional equivalent thereof. I guess they're also futuristic, anticipating cloning. So although these ballot initiatives have failed in states like Alabama and Mississippi, local prosecutors have acted as though they passed and prosecuted women for things like stillborn miscarriages and drug use while pregnant. Many states, including Kansas and Tennessee, are considering legislation that would require doctors to report all miscarriages, potentially widening the number of women who are subject to criminal prosecution. The effect of fetal personhood, as one commentator put it, results in the criminalizing of pregnant women, stripping women of the right to decide how their pregnancy should proceed, and it uses draconian tactics against grief-stricken women in the wake of bad pregnancy outcomes. So what about the impact of these fetal personhood statutes or prosecutions on women of color? As a result of the spread of this fetal personhood movement, many women of color continue to experience governmental intrusion into fundamental life choices, particularly when they make choices to carry a pregnancy to term or to become parents. In short, their bodies are not theirs alone when it comes to state regulation. For poor women of color, the choice to exercise their reproductive capacity, that is the choice to have a child, often brings with it a host of interventions justified by state interest in the fetus that are often found to supersede the liberty and autonomy interests of individual women. Indeed, pregnant women of color have disproportionately been subject to surveillance as a result of their reliance on public benefits. They've been subject to drug testing while seeking services at public hospitals, arrested and prosecuted for making choices regarding pregnancy care that deviates from their doctor's orders. Women of color are vulnerable to surveillance and later to prosecution, given that they often rely on governmental entities, as Dorothy Roberts and others have noted, and programs that sort of by definition or as a result of their participation in those programs, intrude on the most personal aspects of their lives as a basis for providing services. In various institutional contexts, such as immigration, prisons, social welfare, they are subject to behavior policing policies that limit reproductive autonomy or punish the choice to become a parent despite having something like, for example, a drug addiction. Moreover, this form of behavior policing of women of color functions to reinforce their subordinate place in the racial hierarchy. It reinscribes notions of gender and racial deviance. And by this I mean that the denial of liberty and autonomy is based on gendered normative standards of how pregnant women are to behave. And these normative standards are often based on the behavior of white, middle-class, heterosexual women. And so when poor women of color are not able to meet these standards, they are subject to these behavior policing policies and potentially prosecutions. And government intrusions into the decision to parent is invoked where one is deemed to have deviated from these norms, and in a circular sort of fashion, stereotypes of maternal deviance in turn allows continued state intervention. In some, women of color are singled out for suspicion and intervention because they are deemed to be in places occupying the status of parent or mother that they don't belong. Women of color, particularly Black women, have been associated with stereotypes of Black maternal unfitness and immorality. They are blamed, rather than institutional inequality, for example, for all manner of social ills, ranging from educational outcomes to gun violence. This distrust of poor Black mothers in particular is what justifies the surveillance and supervision of their reproductive choices. This is exemplified not only by the state interventions I'll discuss in just a moment, but also at the level of public discourse on the subject of abortion. We can take, for example, billboards that went up in Black neighborhoods in New York City in 2010 that read, "The most dangerous place for a Black child is in its mother's womb." Similar billboards were placed in heavily Latino neighborhoods in Los Angeles, and these billboards were translated into Spanish. I guess this is an example of conservative outreach to Latino communities that we've heard so much about. So these reflect this idea of maternal distrust and devaluation and stigmatization of Black women and Latinas as mothers. Given these dynamics, constraints on their choices to become parents are a reflection of social views that women of color, in particular, are attempting to access a space that is inappropriate or one that they are not equipped to navigate, particularly when compared to the normative standard that I've described. The race, gender, and class identities of women of color, when attached to their choice to become parents, often raises a suspicion of wrongdoing. Consequently, they confront significant regulation of those choices and are often subject to, as I mentioned, to surveillance. So now I want to talk about this notion of the disproportionate criminalization of women of color. So women of color have been, as I said, disproportionately impacted by criminalization. They've been prosecuted for suffering pregnancy losses, like Renee Gibbs, for disobeying doctors' orders, and they've been prosecuted when they're suspected of using drugs or alcohol, and arrested, and in fact have lost their liberty as a result of these prosecutions. These arrests and prosecutions take place even when there's no evidence, to the point about a lacking in scientific basis, when there's no evidence of harm to the fetus and women give birth to healthy babies. A recent study co-authored by Lynn Paltrow of the National Advocates for Pregnant Women found that between 1973, when Roe was decided, in 2005, there have been at least 413 cases when, as the report notes, a women's pregnancy was a necessary factor leading to the attempted and actual deprivation of liberty. There have been 200 cases just since 2005 in which pregnant women were arrested and subject to prosecutions for choices related to their pregnancies. These states have often used personhood statutes or have attempted to use existing criminal statutes to advance these prosecutions. And I want to give you a sense of the types of crimes that these women have been charged with, or the types of conduct that led to these criminal prosecutions. One is a woman who delayed having cesarean surgery. Another is a woman who experienced a miscarriage after taking medically prescribed Depo-Provera. Another was prosecuted after experiencing a stillbirth at home after trying to have a natural childbirth. In all of these cases, there have been racial disparities. Over 52% of these prosecutions were African American women. 60% were women of color. And these are just the criminal cases. In civil cases where women have been, when women's liberties have been restrained by the state, for example, for rejecting cesarean sections or blood transfusions, they have more often than not lost despite making arguments about religious claims to religious liberty, for example, when Jehovah's Witnesses and others have made claims. So women of color, in particular, have not been able to leverage the notion of reproductive liberty and accommodation. So I want to make my last point. I guess I'm over time here. Just a little bit of time, okay. So the last point I want to make is about the way that these prosecutions shift the obligation from the state, shift obligation away from the state to address issues, the institutional issues that lead to pregnancy losses or negative pregnancy outcomes. The state of Mississippi, where Renee Gibbs was prosecuted, Black women are 1.5 more times than their white counterparts to give birth prematurely, and Black babies are twice as likely as white babies to die before their first birthday. Now, Mississippi has some of the highest rates of maternal loss and child death, particularly for Black children. What are the causes of these things? It's not just the maternal choices. It's poverty, lack of access to health care, lack of access to stable housing, all contribute to these figures. But even when income is controlled, it doesn't account for this disparity. What researchers have found is that racial discrimination and microaggressions also contribute to these sorts of miscarriages or premature births. And so the prosecution of women of color, instead of focusing on these particular institutional factors that lead to negative pregnancy outcomes, focus the attention of society, focus the attention of prosecutors and other lawmakers on the individual choices of Black women, and reinforce the notion that Black women are bad mothers and deserve the prosecution that they receive. So I think I'm going to stop there and talk about some of the implications of these patterns of prosecution and the turn away from institutional responses to these sorts of dynamics and the turn to private prosecutions of women of color. Thank you.
Thank you, Priscilla. Allison is next.
Good morning. Thanks very much to the conference organizers for bringing all of us together for these thought-provoking discussions of religious exemptions. I also want to thank Professor Nomi Stolzenberg, who launched a religious accommodations project at USC that is largely behind the organization of this first conference. I'd also like to thank especially Dean Martha Minow for her brilliant analysis of this topic in an article several years ago that sparked the interest of many people in this topic of religious exemptions from civil rights laws. And finally, I wanted to acknowledge a former doctoral student of mine, the first student I had, Dr. Martin Dupuy, who is now a dean at the University of Central Florida, who, after the Hawaii case, wanted to write his dissertation on same-sex marriage. And I'm in political science, and I got a lot of grief from my colleagues who said this is an obscure topic, what does this have to do with American politics, he'll never get a job, and so on. So he got tenure and at a university in Illinois, and got interested in a little-known senator there nobody was writing about, Barack Obama. So he seemed to have a good eye for topics. So anyway, his first book, Same-Sex Marriage, Legal Mobilization and the Politics of Rights, was published in 2002 by Peter Lang. I think it was one of the first books, if not the first, on the subject of same-sex marriage, or now marriage equality, although I don't see it cited very much in the legal literature on the topic. And a few years ago, he co-edited a 3-volume work defending same-sex marriage. Martin Dupuy is at the University of Central Florida and is someone I think may be of interest to law professors. So my approach has been to take a socio-legal approach to the question of civil rights protection, and I also favor looking for compromises. I reject the view that compromises are impossible. Obviously, in some areas, we won't be able to find a consensus or a compromise, but to the greatest extent possible, I think we should look for policies that can accommodate both sets of rights that are involved. I also want to argue that we should take a comparative approach to these topics because it's certainly the case that these rights conflicts occur across the globe, not only within the United States. And I think law professors benefit from using the index to foreign legal periodicals to be able to take stock of the developments in jurisprudence in other parts of the world. So this panel was asked to look to the future. It's a fact that Americans are rather obsessed with future orientation. That's part of our culture. But it seems that we're worried that if the Supreme Court accepts religious accommodations or religious exemptions, that there might be a trend towards the recognition of more religious exemptions. And so I want to explore the issue of exemptions, some sort of analogies where there have been exemptions granted to general laws, and think about the implications of granting these. So in work I've done before, I've looked at religious defenses as part of cultural defenses. And the basic position that I take, or the argument that I advance, is that we should apply a principle of maximum accommodation, that where cultural rights and religious freedom are involved, where the recognition of these rights are involved, individuals should be allowed to follow traditions that are important to their way of life, or ways of life. And the limiting principle for me is irreparable harm. So where there is physical harm, it's easier to say that a particular tradition or belief is unacceptable. It's clearly much more difficult to ascertain irreparable harm when we're dealing with psychic injury and what sorts of psychic injury and trauma constitute irreparable harm. And that's something that's been recurring, I think, in the discussions. I think it's pretty obvious that we've been grappling with a kind of rights conflict, what people in human rights call a hierarchy problem. So we're dealing with this fundamental tension between the right to religious freedom on the one hand and the right to equality and non-discrimination on the other. And so many people in civil rights and human rights tend to be advocates of one particular right, and I think we don't often look at the interrelationship among rights sufficiently. We need to be able to determine the relative priority of particular rights. And what we've heard, I think, over the last couple of days is that people take differing views on the ranking of these different rights. It could be that even if religious beliefs can be shown to be sincerely held, that if granting exemptions based on these is traumatic for people and constitutes irreparable harm, that the exemption can't be granted. But people weigh these things differently. So I want to then say a few things about what we can learn from the cultural rights debates that relate to these general discussions of this basic conflict. One is that the right to culture and the right to religious freedom, that these rights are part of international human rights law that is binding on the United States. So the United States has ratified the International Covenant on Civil and Political Rights, and it guarantees in Articles 27 and 18 the right to culture and the right to religious freedom. So at least in principle, because the U.S. has ratified this treaty, as have most countries in the world, virtually all, the commitment to protecting these rights exists within the U.S. legal system. There is no limitations clause for the right to culture in Article 27, but in Article 18, in the third clause, there are provisions that provide for limitations based on public safety, public health, and public morals. So I think that's at least worth bearing in mind in the context of this debate. The other thing that we haven't really talked about is this tendency to denigrate culture, that people at the meeting have tended to dismiss culture as the culture wars, which is a phrase, in my experience, that's usually used by conservatives as a way of dismissing particular traditions that they find hard to understand. Liberals tend to use the term boutique multiculturalism as their way of denigrating the recognition of different worldviews. So we're focusing primarily on religious exemptions, but we've invoked culture at various points, and I thought it's interesting the ways it's come up. The other thing that's concerned me in our dealing with culture is that we've tended to conflate religion and culture. So people have referred to honor-related violence as being based on religion, but that's not based on religious texts. That's, I think, erroneous. And it certainly, there are many cultural traditions that value honor and think that violence can be justified in the name of honor. To me, that would be an irreparable harm to the person who's killed in the name of honor, so I would reject that. But my point is that people are linking particular traditions to religion when there's no basis for that. The same could be said of female genital cutting as well. So where the law takes account of religion and culture, there are a number of ways that this can be incorporated in legal proceedings. And one is as mitigation in criminal cases. Another is exemptions from general laws, and these can be granted either by courts or legislatures. And a third set of disputes would involve culture or religion being brought in as a factor to increase the size of damage awards. And there the argument is that because of the person's background, the person is more traumatized by the negligent act than a person would be from the mainstream. So let me turn now from these sort of general remarks about the relationship between culture and religion to some illustrations of exemptions. And I think that often commentators express a fear that granting exemptions will undermine the law, that it will lead to anarchy, that somehow granting exceptions will create a crisis in confidence in the law, and that anarchy will result, or that there'll be the law won't be regarded as legitimate. And I think this dates back to the Reynolds case, the case involving plural marriage or polygamy. So if more exemptions are granted, we will see more expression of these kinds of concerns about the status of the law. So there have been a set of exemptions granted in the area of food safety. So there have been a number of situations where public health inspectors have been concerned that restaurants that have food that's not kept either hot enough or cold enough, that will cause food poisoning or some kind of illness. So in one example, the food safety inspectors tried to close down Chinese restaurants because they serve Peking-style duck. You may have passed restaurants where you see the ducks hanging in the windows of the stores. Well, those aren't either hot enough or cold enough according to what food safety laws require. So eventually, the legislature adopted an exemption to allow people to continue to eat Peking ducks. And here there was really no harm because people had been eating Peking-style ducks for thousands of years and no one had ever gotten sick. So in the absence of any empirical evidence, there didn't seem any reason to regulate this. A similar controversy more recently dealt with Korean-style rice cakes and the cakes that had a kind of filling that had to be kept at a certain temperature. And the argument of these ethnic communities was that if you had to keep them at the temperature that the law required, it would destroy these delicacies. So here, the accommodations were made, and there was no great disaster that ensued. In some other areas of foods, more recently with the shark fin soup, there was no exception made for that because of the rights of sharks, and because of concern about cruelty to sharks and so on. So in some areas, exceptions have been made, but people seem to be able to draw distinctions about areas where they think it's acceptable to accommodate and where it isn't. Another area where we've already talked some is where religious exemptions have been granted for the ritual slaughter of animals for Jewish and Muslim communities, so that the meat is glatt or halal, and there is no harm to humans. There may be harm to non-human animals. We've also discussed religious exemptions, I think, for Sikhs who want to wear the turban, and they're given exemptions from occupational safety laws so they can wear the turban instead of the hard hat. In the United Kingdom, there was also an exemption granted for Sikhs to wear the kirpan, the dagger that's required, exceptions from the weapons or knife law. And most recently, there have been some exemptions granted from noise laws. I've recently been writing about loud religious sounds and whether there should be exemptions from noise laws. In the early 20th century, the litigation dealt with church bells that were thought to disturb the peace, and eventually the sound became familiar and faded into the soundscape. The current disputes around the world have to do with a call to prayer, and so that's another area where religious exemptions are sometimes part of the law. Now, in these examples, the cultural and religious exemptions didn't cause harm to anyone. There was at least no physical harm. But people sometimes objected on the grounds that this gives special treatment to particular ethnic or religious communities, and people who subscribe to the when in Rome philosophy, what I call the monocultural paradigm, object that this will undermine the law. But my view is that this kind of argument reflects a kind of cultural bias or ethnocentrism. Now, there are religious exemptions that certainly do involve harm, and we haven't, I think, discussed these at all at the meeting. Some of the exemptions that exist, the statutory exemptions, protect Christian Scientists who do not take their children to the doctor. They have exemptions in many, many states, except for just a few, so that if they don't take their children to the doctor, but instead take their children to see a faith healer, they can't be prosecuted for manslaughter. And where this has been litigated, state Supreme Courts have said that this violates due process because if parents are told that they're not subject to child neglect laws, how are they supposed to know what point they're subject to these manslaughter laws? So it's a failure to give notice to parents as to when the law requires them to take their children to the doctor. Now, those exemptions seem to involve irreparable harm to children who die from lack of medical treatment. So religious exemptions are not all equal. In some cases, accommodations can be made, and in others, we ought to question these. My final example involves the tension between disability rights and religious freedom. And there have been various cases in which taxi drivers, for religious reasons, will not allow people who have a visual impairment in their cars because they have dogs that accompany them. And the argument is, and in one case, there's Gilmore versus North Shore Taxi, a blind Vancouver man wanted to take a taxi, and the taxi driver was Muslim and refused to take him. And it went to the British Columbia Human Rights Tribunal, and ultimately it was settled out of court. And the policy, which was a compromise, gave Mr. Gilmore $2,500 and stipulated that the cab company adopt a new policy. And the policy was that the taxi cab driver would have to register his religious objection and would have to immediately call for another cab driver to take the blind person in the cab. So this policy is an illustration of attempt to try to balance protection of the rights of persons with disabilities and the rights of religious minorities. And because blind people often experience this problem that taxi cab drivers drive off and they obviously can't see the license plate number to complain, it's difficult for them to file complaints. So anyway, I mentioned this as an example of where we can learn from the tension between disability rights and religious freedom to resolve these conflicts. The problems with exemptions sometimes are that recognizing an exemption for one group will lead another group to say that based on equal protection, they should also be entitled to an exemption, and that could lead to an increase in these kinds of arguments. But as I hope I've shown, there isn't necessarily a reason to be concerned depending on the nature of the exemption that's requested. And my final point is just that if we do take this comparative approach that I urged at the beginning, we can see that in the European Union, there has been a great deal of discussion about women's access to medical care and conscientious objections, and there's a great deal of discussion about the need to regulate more carefully the invocation of conscientious objections where women are not given alternative access to abortion and medical care. So I think there is a lot we can learn from other legal systems which we may want to discuss at our next time this group is convened. So finally, I hope we can find more compromises than some people thought were possible, and I'll be glad to discuss any of these things later on. Thank you.
Thank you. Catherine?
Indulge me one second here. Cool. Okay. We have arrived at the end, and I am the end. To my great relief, and probably yours as well. This has been such an amazingly productive, infuriating, satisfying, and intense gathering. So I want to thank all of the organizers for the incredible hard work you all did in bringing us together. It's been a really important gathering. So Nan Hunter yesterday took up an idea that Mark Tushnet had introduced on the opening panel. And this idea is to undertake some critical thinking about the political space cleared out, if you will, by the assertion of religious freedom and religious free exercise rights. So it's there I want to pick up the discussion. I think we have ample literature, ample academic literature, thinking through and defending the case for robust respect for religion, for norm pluralism, and for the legitimacy of religious exemptions. Also, I think in many cases for the necessity of those religious exemptions. These scholars and advocates want to defend the importance of the demand that rules promulgated in the name of the secular must yield in the face of an objection from the vantage point of religion. The literature on the other side, by contrast, on the side that is somewhat skeptical of the claims put forth by Hobby Lobby and Conestoga Wood, I think have not been as well developed. So I've recently launched a project at Columbia Law School that aims, among other things, to generate some of that critical scholarship, to think about where the gaps are, and to try to fill those gaps in the academic level, the policy level, and in litigation. We've just hired the fabulous Cara Lowenthal to direct this project, and it's been very exciting just beginning to work with her. And one of our first tasks has been to map out some of the most common arguments or frames that are used by those of us who are concerned about the political space that might be created by judicial and statutory grants of generous and robust religious exemptions. Jane Wishner, a well-seasoned reproductive rights litigator, is here, and I'm thrilled to have her here with us, and she's helping us out with some of the research in this mapping project. Thank you, Jane. So I want to run through, as a preliminary matter, some of the frames that we're looking at, and I want to do it pretty quickly, as many of them will be familiar to you, and some of them have been raked over, if you will, during this last couple of days. So they don't deserve my full elaboration. But one or two at the end I'll spend a little more time on, as I think they engage some of the issues that perhaps we haven't spent as much time on. So the first is that Hobby Lobby-like exemptions unconstitutionally shift the burden of religious belief onto unwilling third parties. We spent a lot of time with this idea the last couple of days. Marty Lederman certainly talked about it in his work. It was Verrilli's really lead argument in the Hobby Lobby case. And I think this is an important claim not only as a legal or doctrinal matter, because certainly there is doctrine we can turn to assert this claim, but it's also an important political claim, one having to do with competing notions of fairness and the costs of respecting certain forms of rights. So I'll say no more about that because I know you're all familiar with it. The second is that granting the exemption violates the Establishment Clause. This is Fred's argument. One version of it is that it favors religious over secular values. Another version of it is that it creates a constructive subsidy for religion, and these are different arguments that have different valence, but it's an important one, and it's one that I think has gained quite a bit of attention in the media and in the courts, particularly around the framing of the Supreme Court's exemptions cases in the Affordable Care Act context. Let's see, the third argument is that the exemptions amount to a form of sex discrimination. And this was Louise's argument in the brief that the ACLU filed in the Hobby Lobby and Conestoga Wood cases. The claim here is that the protection of both abortion but also contraception rights are essential to women's equality in the wage labor market and in other aspects of public life. And to understand contraception as merely medicine or a device is to underconceptualize and neglect the important role that the ability to control one's reproductive life play in women's freedom in a range of contexts. The second argument related to this is that the exemptions amount to a license to discriminate. So it's to reframe the exemption as a license. And the third is that the exemptions create special rights for religiously justified practices that in all cases or in many cases trump the rights of competing rights holders. And it's an interesting response to the special rights arguments, I think, that are made often to criticize the rights of lesbian and gay people in a range of contexts. So the third, by the way, this last argument was made not only by the ACLU, but also by the National Women's Law Center in their brief in the Hobby Lobby and Conestoga Wood cases. So the fourth argument is that frame is that the exemptions are the backup plan. They're plan B when you're the loser in a battle fought in elsewhere through the democratic process. And to some degree, Louise has made this argument as well. Many of others of you have, when you're unable to defeat the civil rights change, civil rights progress in a democratic context or in court, the fallback position is to say, oh, right, you can have your right. It just doesn't apply to me, and it doesn't apply to me and my people because of a set of religious exemptions. There are historical contexts where this has been asserted before, some of what Bill, I think, was rehearsing earlier in this panel, evidence some of the historical context where the turn to religion is plan B. But it's also, in other ways of framing this particular approach, understood as a kind of end run around losing through the democratic process. So the fifth argument, really distinct from the others so far, is that exemptions are actually bad for religion. The heck with you people who want to assert the rights, civil liberties on the other side. Exemptions are bad for those who assert them. And so Winnie Sullivan in her work, and I think Phil Kurland in some of his work, have made the argument that they necessarily entangle the state in declaring religious doctrine by picking out a particular value and then lodging it within the frame of religion. And that kind of state sanction of state declaration of what counts as religious doctrine is bad for religion itself, as it necessarily entangles the state with religion. And then secondly, the exemptions are bad for religion because they result in the state's endorsement of a particular religious view within a complex terrain of religious beliefs. So it actually constrains religious liberty among peoples of faith for the state to sanction one particular religious view in a case, like the reproductive justice cases, where, of course, there are many people of faith who favor reproductive rights. And to choose a particular conservative approach to reproductive rights will have the effect of constraining religious liberty within religious communities. And this was the argument made by the Americans United for Separation of Church and State in their brief in the Supreme Court recently. And Brian Barry, I think, has made this argument to some degree in Culture and Equality. 6, governments ought to be neutral as between religious and secular values. Larry Sager, who's ghost is sort of haunting us here. He's not here, but certainly that's his argument. It amounts in a way to discrimination against secular beliefs, or it prefers a religious over a secular reason, and in doing so risks establishing religion in violation of the other religious clause. 7, and now we're getting into the stuff that I like because it really engages questions of culture in a thick way. What counts as religion itself is an unstable category. And to assert it as a perilous, as the basis for an exemption for otherwise universally or generally applicable laws is a very perilous project. Bill, I think, referenced a little bit of this in his discussion earlier, in the sense that those claims which could reside comfortably within the domain of religion are a moving target. over time. Religion itself is a normative set of commitments that evolve over time. And I think that's an incredibly important point that Bill made in the Georgia piece that he published earlier in his remarks today. But I think we can push it even further and say, as some have, that the domain of something marked as religion gains legibility and even coherence in response to particular exertions of state power. Indeed, the thing that gets organized and rendered legible as religion is an epiphenomenon in important ways of the exercise of state power. And there's an ample literature on that kind of thinking by Anne Pellegrini, Janet Jacobson. I guess we could go so far back to Foucault, of thinking about forms of governance and how they're deeply implicated in one another, both in the state side and on the non-state or religious side. 8, the exemptions should be seen as related to a larger political project of shrinking the domain of the public through the assertion of a normatively superior counter-public named as religious. So Melissa and Liz both, I think, referenced in their remarks the idea of the shrinking state, of how the assertion of religious exemptions really collaborate in a much longer assault on the legitimacy of state jurisdiction and funding of a range of aspects from the family, as Melissa said, but certainly to other aspects of social life. And I think in an important way, the exemptions produce and legitimize religious belief as what I'm beginning to call a kind of portable temple that one cloaks oneself in and enables one to pick and choose which other public norms and public laws one will comply with as one moves through life, whether it's in a commercial setting or the private setting of where the temple normally is thought to reside, but as one moves through both public and non-public spaces. And when there's a conflict between the values in your bubble and the values that you're being confronted with, either state values or other values, your bubble always insulates you from compliance with those competing values. So the last frame I want to talk about is to understand the religious exemptions as really a strong form of an assertion for legal pluralism. And in this sense, what they amount to is a demand that the state and other citizens acknowledge that the party asserting the exemption regards themselves as being governed by two competing legal systems, one secular and the other religious. And when the demands of those two systems come into conflict, the request for the exemption amounts to a claim that the religious law should be treated as supreme. When I listened to Anita Allen's presentation yesterday about the woman who wore the hijab in court, it struck me that what was going on there could also be understood, apart from how she was explaining it, as a claim to a kind of legal pluralism. Her hijab actually represented her pledge of allegiance to a competing legal and normative regime, one religious in nature. And for this reason, asserting the right to the veil in the courtroom directly confronted secular legal authority with a challenge to the monopoly it claims to governance. In this sense, what we witness in the clash between the veiled woman and the robed judge is the assertion of a particular kind of compelling state interest, but a very different one than we normally think of, the interest of the state itself in the United States context to demand allegiance to a singular secular source of legal authority. Unlike in South Africa, India, or Israel, for instance, pluralistic legal cultures, we have a very strong tradition of a unitary source of law here in the United States. And in those pluralistic legal cultures, they have decided to delegate important aspects of civil authority to religious groups over matters such as the family and property law. So in important ways, the claim to religious exemptions poses a serious challenge to that singular authority of law in our culture, of secular law in our culture. Some of us have argued that the Free Exercise Clause asks no more than that we tolerate religion and that the norms that are generated in its name be protected behind a veil of tolerance. But as Wendy Brown has taught us in her work, tolerance asks very little of us. And in fact, it can often be a kind of negative claim, but it certainly is not able to assert a claim on the political. It is at bottom a discourse that depoliticizes the claims that are made in its name. In this sense, claims to religious exemptions do much more than assert a demand for tolerance of value pluralism. They present a challenge to the unitary sovereign authority and general applicability of secular law. They mobilize a direct challenge to the political by and through an unambiguous claim to governance. Not coincidentally, the claim to a kind of political power from the camp of religion that we've witnessed today in the important reproductive rights and gay case, or same-sex marriage cases, is in, I think, direct reaction to similar claims made on behalf of gay people. A demand for tolerance could not have mobilized a substantive right for marriage for same-sex couples. And a claim to tolerance cannot justify the arguments made by Hobby Lobby or Elaine Photography to be excused from governance by secular legal norms and in their place substitute the commands of a competing form of authority. To launch such claims requires a kind of will to power that well exceeds the demands of tolerance. And we will be very well served, I think, by committing more thinking to the very nature of the kind of power mobilized by these sorts of claims. This is where I imagine real work and hard thinking is yet to be done. The gay community has pursued a democratic, political process to change the law on the basis of substantive claims to justice made internal to the governance authority of secular legal principles. And the law is changing in response to that process. A mere plea for tolerance could not have launched that project. By contrast, the claim to an exemption grounded in religion represents a claim to authority made from sources exogenous to the secular legal system itself, and in profound ways poses a determined threat to the idea of state power and to singular legal authority. The implications of this kind of claim are, in my view, really quite radical and deserve much deeper scholarly attention to unpack and elaborate the kind of political promiscuity that they may open up. I had to get promiscuity in somewhere. Thank you.
This is very interesting. I had thought Catherine was going to have the last word, and I had no idea what her word was going to be. Now, but I'm going to have the last word now, and then we'll take Q&A. Now, I don't know if Catherine's read my book called Against Obligation, The Multiple Sources of Authority in a Liberal Democracy, but as I heard her talk, it sounded to me as if she was doing a book review of it and critiquing it at basically every turn. So I'm going to just take this moment to lay out the counter-argument to Catherine, and it's not an argument necessarily for how Hobby Lobby should come out. In the book, I argue, I try to seek what a political theoretic predicate may be for a system of accommodations and exemptions. I look at literature on political obligation and political legitimacy and argue that the two are correlative, that they travel together. Not everyone believes that. That we don't have a prima facie moral duty to obey the law on various grounds that are offered. I reject all of them, and that correlatively, the state does not have a legitimate claim on our obedience. If I'm correct in those arguments, and I travel through a lot of very familiar territory there, the ground for deeming the state's claim that its law deserves a presumption pride of place is undercut. And it opens the door, I argue, for something I call permeable sovereignty, which is that we should view sovereignty as not plenary in the state, but as permeable through to all of our other sources of norms, such as, importantly, religious ones, which for many people are extra-human sources of normative authority. And that, for me, grounds an argument for a careful system of accommodations and exemptions in a way that Allison, I think, helpfully pointed out. Let me just say that this is not an argument for legal pluralism the way Catherine suggests. It's not an argument that the religious sources of norms or law should become governing. In other writing, I've argued that the Establishment Clause should prevent that. It should prevent dominant sources of religious authority from becoming governing law. The request is for exemption or accommodation, not for control otherwise. So you might call for value pluralism or normative pluralism, but not for legal pluralism. And the only other thing I'll say in this regard is that as Doug Laycock revealed his stripes a bit, as an open-ended agnostic Jewish person, I've always found it very important to take religious people's claims seriously, especially claims about their belief in God and their belief in what follows from that. And sometimes I fear that some of the opposition to religion, such as in Brian Leiter's recent book and other writing that some of you may have read, takes a rather wholesale, robust approach of an attack on religious belief, on the possibility of having planes of knowledge and planes of belief that are different from science. And I think if we're to take religion seriously, we have to be open to the possibility of what it means to be religious in a theistic sense. So I think we'll do Q&A is what we want to do. So let's start with whoever there is. Marty.
This is a great panel, thanks. I don't know if this is on. Can you hear?
Yes.
Leaving Catherine's wonderful matrix up here, I'm going to suggest, first of all, I have a question for Catherine and Bill, I guess at a point that it's step 0, or maybe it's a different framing. Bill suggested, Catherine, that another thing is just wholly outside the justifications for religious exemptions. We might want them as a way of tempering our disagreements and allowing progressive legislation to be enacted. It's a necessary condition of getting the legislation enacted. So I imagine that if the court rules for Hobby Lobby and very broadly construes RFRA, there will be many on the, I'll just call it the left, who will abandon RFRA, become very hostile to religious exemptions in a lot of different areas, become much more wary of them. And I think Bill makes a good point, which is that there might be a cost to this in terms of if ENDA doesn't have a religious exemption, it's much less likely to be enacted. And so there's just that very pragmatic political reality that I don't know if it fits in your list or not, but I'd like to hear you and Bill go ahead. Then I think one thing that's kind of been missing, or it's been lurking throughout the entire day and a half, 2 days, maybe it gets to your point 9, is why is this about religious exemptions rather than more broadly about conscience-based exemptions? And some are clearly religious for the reasons in point 9, an alternative theory of obligation, you said, of legal obligation. There's a greater source of power, or you'd probably want to build into 9. 9's going to become 10, 11, 12. Bob covers nomos and narrative, creating different nomos and a different community of understanding of law. But also, when it's a religious exemption, it's often I am subject to 2 masters, right? God and Caesar, and I have to decide between them. Don't put me to that choice. That's how the Hobby Lobby case has been litigated. But what's really interesting is that a lot of our exemptions, not many, but the Title VII exemption, the selective service exemption, many, if not all of these conscience-based hospital exemptions are not limited to religion, right? They are anyone with a moral or conscience-based objection gets out of the obligation. And when it's expanded beyond religion, it gets rid of 2/3 of the objections, the Establishment Clause rejection and all sorts of other things. The expansion of the exemption beyond the religious to just anyone with a conscience has this dual effect of getting rid of a lot of the problems, but at the same time carving out a greater space where the generally applicable law, is not generally applicable. And I think we need to think about that more, and I'm not sure how it fits into all this, but I'd love to hear your views on that.
I'll start by agreeing with Marty, but then I want to put it in a different way. Yeah, I think you're right. I explicitly would add to Catherine's list, although I like 9 as like a number. It's 3 times 3. So it's a religious number, right? So I would say, yes, I think one role of religious accommodations is that they facilitate compromise. There are many documented studies. Harvard CRCL did the best article anyone's ever done for a state anti-discrimination law. The Massachusetts law was published about 20 years ago. And it makes it quite clear, and there are other case studies of other laws. You could not have passed like 1989, the Massachusetts anti-discrimination law, you could not have passed that without religious accommodation. I will tell you in Connecticut, we could not have passed the marriage equality statute without religious accommodation. But I don't think it's just that, exactly as you're suggesting. I think it's stakes lowering as well, which has virtues beyond just getting something passed. That's exactly what you're saying. Here's how I would put it, however, in a different way, which is suggested by my ending with Boy Scouts. And that is that I think the religious accommodation provisions are also potentially dialectic as well. It's another way of looking at them, is they do create a dialogue. And plagiarizing from yesterday, where there was a lot of discussion, look, if you want to take advantage of one of these accommodations, you've got to be public about it. You know, put it on your website. You've got to announce yourself. You know, this was Justice Stevens' objection in Dale, the Boy Scouts case. The Boy Scouts were kind of making it up as they were going along. And Stevens says, you know, take a normative position and admire that in your tradition, rather than just making it up by the lawyers. And I take that. And so another way of thinking about the religious exemptions, or conscience exemptions, as you're very usefully suggesting, is to say, yes, if an institution, or more likely a person, wants to say, my identity, where I'm coming from, my faith, my whatever, is anti-gay. Well, that will start a conversation if that becomes public. If there's an exemption, that's not the end of it, that they fall under the exemption and therefore they cannot be sued. They might actually be sued, there's litigation over that, but this is going to be a public moment. And there's a way in which the punchline I'm trying to convey by the comparison to the Civil Rights Revolution is that it's not just the law all the way down, or even the bottom-up conversation that Kluger talks about for change, but it's dialectic, that victories are achieved, communities are changed, conversations are put in place, fire hoses are used on African-American youth, and that provokes intense media coverage that actually that changes people's minds, is the intense media coverage, the intense conversation. So I would suggest, I don't know, we really do have to defer to experience. They work differently in different areas. But I would suggest that religious accommodations have a dialectic kind of frame.
Thanks. Catherine, did you want to jump in on that?
Yeah.
Potentially.
Well, I don't have, there you go, Marty. I don't have Marty and Bill's ideas on my list, because those are defenses of the exemptions, of their legitimacy. And I was trying to come up with a set of progressive, from the left, accounts of why we might be troubled by the exemptions. And so I take your point, but I think it's a different list.
Okay.
It's a complicated thing, yeah.
Right, but as she stated it today, it was. Louise, are you?
Yes.
Wait,
So-
I wasn't finished. If I
Sorry.
could just
Oh,
really
sorry, go ahead.
quickly say, I think we should have, from the very beginning, refused to include exemptions language in the marriage statutes, the equality statutes that have been passed or brought up in state legislatures across the country. We have a constitution that can handle that. We have constitutional doctrine that can handle it. And I think it's a failure of coalition politics on the part of the gay community to think about a single issue and only how it affects us. And we've let women of color, we've thrown them under the bus, we've thrown reproductive rights under the bus. I think we haven't thought about the complexities of our own communities that will be negatively affected in ways that have nothing to do with marriage necessarily. And I think it's a very short-sighted and dangerous strategy to say marriage at all cost. And we will undermine civil rights laws more generally by allowing these really robust religious exemptions clauses to enter these statutes. And Nelson's arguments around a close reading of these religious exemptions clauses has really convinced me that they're a real problem. And marriage can be accomplished in other ways. And I have a whole totally subversive political project that I'll let you tease out of me. It's an alternative.
I'm
Yes.
just curious, Bill, how you would comment when you talk about accommodations as, stakes lowering. How do you then apply that to what you heard yesterday from Doug and Riva? How do you apply to Doug and Riva? I understand the story where you can tell vis-a-vis race, or the story you can tell vis-a-vis LGBT, but what about that other?
Yeah, the way I would answer that is suggested by my question yesterday. I think each different kind of politics involves different norms. And so for women's equality, I would insist on breaking it up. On women's equality issues, broadly speaking, can women serve in the military? Can women be lawyers? Can women be paid equal salaries? On those issues, I think the social movement has been relatively successful. Not entirely successful, relatively successful. On issues like sexual harassment, I think normatively the movement has been relatively successful. On the ground, not so much. The issues on which, as I read the polls, the women's movement has been least successful have been issues like abortion, which are normatively very complicated for a lot of people, including a lot of women. The poll numbers on abortion are not that men are pro-life and women are pro-choice. The numbers are very, very mixed. And I think on that kind of politics, Riva and Doug have hit the nail with their head. That I think that is a real danger, the sort of Pandora's box danger. You open up one and continue on the others. I think, on the other hand, in areas where the social movement is having traction with middle America, women's equality, LGBT equality, some of the disability rights movement, maybe not others, then the argument works more the way I'm suggesting. I think the civil.
Dialectic can move in the other direction, right? So church amendment is 73. You're talking about a dialectic where religion changes. I think to some degree the religious exemptions have been a factor, not the only factor at all, in the other dialectic going from, I think you're understating the amount of support A that exists and B existed in the early 70s. Whose stories,
But the reason is what the civil rights movement got, what the gay rights movement got, what the women's movement got was integration. And that once African Americans were at work. No, we're talking about African Americans at work. We're talking about lesbian and gay people in the family. We're talking about women in the military, et cetera, et cetera. And on those issues, I think the reason we've gained great traction is because it has been an immediate falsification of argumentation. I think it's been much more difficult for the women's rights movement to achieve falsification on issues like abortion for various reasons, including the normative difficulty of that.
I just wanted to see if Priscilla or Alison wanted to come in on any of what's been said since you each spoke.
Well, I thought it was terrific, the summary of the different arguments, and I share concerns about religious exemptions in the area of marriage equality. But I think that it's important to acknowledge that the right to religious freedom is important, and the discrimination against people who have religious beliefs is part of the conversation, and the call for trying to have a respectful discussion where people disagree is important. The idea of legal pluralism not applying to the United States struck me because I think the United States does have legal pluralism with all the state constitutions, tribal courts, religious courts. So I'm not sure that it's as different from the other countries as you were describing. And I think there are instances in which people should be entitled to follow the customary law or the religious law. And at this meeting, we've talked about all the anti-Sharia laws as a form of Islamophobia. So I would want to be a little bit more careful about trying to say that the United States has a unitary legal order and that we would reject legal pluralism entirely.
Other questions? Yeah,
Thank you so
I wasn't
much.
sure. Go ahead.
I just wanted to put in a plea, both for thinking about gender in more complicated ways and for thinking about religion a little more complicated, especially with relationship to gender, because it's, of course, the ordination of women that begins to refracture and re-refracture the Presbyterian Church that Bill grew up in and that never had really unified. And it's the ordination of women that begins to surface marriage in the early 1980s and through the mid-1990s in many religious communities. And that has played a very interesting role, I think, here at this conference with conservative religion being primarily represented, not only, but almost exclusively by men, and very acknowledgement, but not presentations on behalf of liberal religious groups who have worked very hard and very long for decades in favor of marriage equality, for example. So I just want to preserve some of that complexity when we speak about religion, religious advocacy, women clergy, and so on. Thank you.
And now for the final word, I give you Doug.
Thanks.
Well, we're at 12:20, so we're already 10 minutes past.
Quick question. We can take the one question.
Sure.
Oh, sorry, I will make it very quick, although that's impossible with how much I have to, I just want to say thank you so much. As a policy person at the National Women's Law Center, this has been very fascinating stepping into the world of the scholars, and all of you are so great thinkers. And so it really makes me feel better that we're dealing with so much difficulty with this Hobby Lobby contraceptive coverage requirement, knowing that there's so much disagreement yet in this room on the issue. So we're not alone. I think it goes on to Louise's point, though, that Professor Eskridge, you were saying, I think, to put it directly, when the government sanctioned that abortion was different, did that then ruin it? Not that it's women's rights advocates' fault, but that we were handicapped from the moment that that church amendment went into place. And so, I was struck by, my colleague and I were struck by the slide that once you got the religious groups engaged, you're good to go, because it suggests that the religious leaders are leading the way of their flock. And I think what happens, actually in contraception, most of the women don't agree with their clergy on the position on contraception, and a lot on abortion. And I think there's more support for abortion than even acknowledged in this room. When people understand women's circumstances, they change dramatically. And so it kind of goes to Priscilla's wonderful presentation, or Professor Osen, sorry, getting to the point of the government deciding what the woman's control over her body is, and when they can define what is the morality, in saying, as I think it was Professor Lederman said, that there are no religious or moral exceptions in church. It is anybody who wants to get out of it. Really making it clear that abortion is something very different. So it's just to present, and maybe not even a question, but just to put out there, is it our fault? Which, as a person who's working on this every day, trying to push back on the state restrictions on abortion and contraception, or is it that when that happened, we were starting at a much difficult position than some of the other discussions we've had? So I really appreciate it. Thank you so much.
Okay,
So a round of applause for this panel,
For the
which has been great.
And the moderator.
And
And a big
Abner,
round of applause for the organizers.
thanks. So Abner and Catherine, neither of them get the final word. I will, which is, I just want to thank, this has been an incredibly interesting and exhausting conference. We've all sort of been doing this now for almost 2 days, and I just want to thank all of the speakers and the folks who presented their work, the folks who expertly moderated panels that could get rowdy, and all of the folks who came and attended and participated in the conversation and asked great questions. I also want to specifically, again, thank our sponsors, including Harvard Law School, Dean Minow, who's been so incredibly generous, the Williams Institute, and Brad Sears, the executive director, the ACLU, and Louise specifically, the USC Law School and its Center for Law, History, and Culture, and thank my fellow organizing committee, Mark and Nomi and Nan and Louise. And again, thank all of you for this really great conversation, which will hopefully continue, especially through Nomi's project at USC on religious accommodation. And she'll be probably looping everyone in about forthcoming events. And most importantly, I want to tell you all to get lunch before you leave. And for those of you rushing to the airport, to at least grab bags of chips and cookies. And thank you again for coming. Thanks.
Thanks, Doug.